Mayor,
On the record, I'm a judge.
so, the jury busted with a verdict, but now they're asking the deputy in charge a question. And, for the record, can you identify yourself?
Deputy Person Stein.
Okay, and what are they asking?
They're just asking for clarification on which, as far as like the signature goes, like which form to sign. They do have a verdict, but they're, I guess, confused on like the lesser part or if they sign all
Yeah.
of them or.
Okay,
No,
why don't you do this? Go and ask the fourth person to write the question and give it to us in writing, and then I'll decide what to do.
okay.
So tell her to, whatever they're asking you, to put it in writing and then give it to the clerk, and then we'll stamp it and then we'll see. Okay, so let's just give her a minute to do that. Can I get one of those, you have all the evidence? Okay, we're back on the record. Just so it's on the record now, the jury buzzed that they had a verdict. One of the deputies came back and said they had a question about where to sign the verdict forms, and I requested that they, foreperson put it in writing. So right now at 5:31 p.m., question, for count one verdict form, do I need to sign the first page as not guilty if I sign the second page for the lesser count as guilty? I'm not gonna answer that. So this is what I'm gonna respond, and then you all can tell me if you have any objections to it. Members of the jury, in response to your question, you are instructed that you have all the law and the evidence that was submitted before you. Please refer to the charge of the court. Please continue to deliberate. Respectfully submitted, Judge Hoy, Pettis, 437th District Court. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Okay, so. Okay, so there you go. So we need to stamp that or not, or what?
Okay, so,
We're back in recess until we either, they figure it out one way or the other, okay?
you may be seated.
I'm just gonna let you know what I'm gonna do if I think what's happening happened. So they are instructed at count one. The question was just count one. It may be that they did this on every count. But it says, now if you find a defendant, that did this, count one, the initial one, then you will find the defendant guilty of count one, right? If you do not so believe, or if you have a reasonable doubt, then you will find them not guilty of count one and proceed to then consider the lesser. If they don't sign count one at all, either guilty or not guilty, but they signed the lesser on count one, then of course I'm gonna take it like count one was found not guilty unintentionally and knowingly, and they only found them guilty of the lesser. Do you understand what I'm talking about?
I understand.
Because, you know, the instructions do say, the way they should do it is, we the jury find the defendant Derrick Coles not guilty of count one, and then they're doing, it looks like from the question, they're doing guilty of count one lesser. Does that make sense?
Yes, sir.
But if they don't sign the higher charge on count one, if they just don't sign it, I'm gonna take it as a not guilty, and then guilty on the lesser. Unless the state objects to that, and I make them go back and you know, tell them, you know, this is an incomplete verdict.
At this point, Your Honor, the state would object and ask that it go back as an incomplete verdict for some time for them to figure out. I don't believe that the acquittal would be effective if not rendered by the jury on the correct grounds.
Why don't you call appellate, your appeals section, and tell them what's happening. You understand what's happening?
I understand exactly what's
They're
happening.
leaving count one blank and they're proceeding to count to the lesser. It looks like they're saying guilty on reckless. It looks like it. I don't know for a fact, but from the question,
Yes, sir.
I just want to know what's the proper way to proceed if they leave count one blank entirely, not guilty or guilty.
Yes, sir.
Does that make sense, counsel? Okay, so let's give it a couple of minutes and call and check with appeals what's happening and tell them what their opinion is.
Yes, sir.
And I'll make my own call.
Hey, I got a question for you. So, on our injury chapter, we have a verdict
And then, if they got it right, well, they got it right. If they got it wrong, then I'll give them that instruction.
Yes, sir.
All rise for the jury.
Yes. Everybody may be seated. Will the foreperson please stand? And sir, has the jury reached the verdict?
We have, Your Honor.
Is the verdict unanimous?
It is, Your Honor.
And has it been signed by the foreperson yourself?
It has.
Will you hand it to the deputy, please?
Yes, sir.
Okay, will the defendant please rise? Okay, count one, verdict form. We, the jury, find the defendant Derrick Coles not guilty. Count one, lesser included offense of recklessly causing injury to a child, verdict form. We, the jury, find the defendant Derrick Coles guilty of the lesser included offense of recklessly causing injury to a child in count one, signed by the jury foreperson. Count two, verdict form. We, the jury, find the defendant Derrick Coles guilty of the offense of injury to a child as charged in count two of the indictment. Count four. We, the jury, find the defendant Derrick Coles guilty of the offense of injury to a child as charged in count four of the indictment. Count five, verdict form. We, the jury, find the defendant Derrick Coles guilty of the offense of injury to a child as charged in count five of the indictment. Count six, verdict form. We, the jury, find the defendant Derrick Coles guilty of the offense of injury to a child as charged in count six of the indictment. Okay, does either side have any motions? Anything?
I think it's.
Anything? Okay, then you may be seated. Ladies and gentlemen, that concludes your participation in this trial. The defendant has elected to have the judge, myself, assess punishment at a later date. And so, your participation is concluded. What I said, earlier, to the panel, I think, that, you know, all of us, if we ever are charged with a crime, we're entitled, primarily through the U.S. Constitution, through the Sixth Amendment, to have a jury of our peers decide if we're guilty or not guilty. We don't like to leave that up to judges generally, and so the criminal justice system for sure would come to a screeching halt without citizens and members of our community, such as yourselves, that are willing to put yourselves out there and do jury duty, as I've stated several times. And I do believe that what we get from our country and what we have to do in return, just follow the laws, you know, pay our taxes, vote, those people that serve in the military, and do jury duty. I think we get a lot in return. And so I think it's a sacrifice, clearly, but it's a small sacrifice considering what we get as citizens of the United States. You're free for my instructions. You're free to discuss it with whomever you need to, Google it, or whatever the case might be. You're not bound by those instructions anymore. On behalf of myself, Judge Juan Perez, and the 437th, the staff, the lawyers, I want to thank you. And so sometimes after a trial, if you all wish, I know it's after 5, you have families and other obligations. Sometimes the lawyers or myself might go and thank you just briefly. If you want to just hang around for a couple of minutes, I'm going to go back there. You're free to also leave the minute you get back there, okay? So don't hold back just because I'm saying that. And so with that in mind, you're excused, and you may follow the deputy back to the jury room, okay?
All right, for the jury.
Everybody may be seated. Okay, so now I guess we're going to get a punished sentencing date. Does either side have any motions?
Your Honor, at this time, the defendant has been vertical cognizance bond pending this trial. We would ask that he be taken into custody and issued an appropriate bond to a guilty first-degree felon. His previous bond was $100,000. We would ask that that bond be once again placed on.
Okay, and counsel?
Now, he's been here every time he's supposed to be here. He's got 3 jobs, takes heart medication and HIV medication, which is at home. I would ask that he be allowed to continue as he is.
Yeah, but, okay, but count 2 is a first degree, and I'm gonna go ahead and take him into custody and remand him without bond for now. You can file a motion seeking a bond, and I'll give you a hearing, okay? So for right now, his bond is revoked, and he's remanded without bond to the custody of the sheriff. And then we're gonna order a PSI with a tap and with a tap. And so just talk to your client about what that is, and then we'll get a sentencing date. Do we have a sentencing date?
Yes, October 20th.
Okay, just everyone note it, and then I'll see y'all back here at that time. Anything else from either side?
Later.
Okay, thank you.
So it's gonna be a matter of.
Yes.
first count was lesser, and then I
Yeah,
think,
that was reckless.
yes.
And the other 5,
I think they were all first.
they were all first
I
degree.
believe
Yeah, because
so.
I heard him say first degree felonies, that's why he was
Mhm.
reprimanded about one.
So only one was second degree.
Yeah, only one was
Okay,
second
that's
degree.
what I
That was-
interpreted it as.
Yeah, no, it was a little kind of